Sports in India are not just games. They involve money, politics, public accountability, and international representation. When athletes represent India abroad, it is not merely a private activity. Questions arise: who controls sports bodies? Can Parliament regulate them? The Constitution divides law-making power between Union and states through the 7th schedule. When Parliament enacts a law like the National Sports Governance Act 2026 to regulate national sports federation, the key issue is legislative competence under Article 245, 246 and the three lists. The National Sports Governance Act 2026 seeks to regulate national sports federations by prescribing standards of transparency, tenure limits, athlete representation, and dispute resolution mechanisms. The constitutional validity of such regulations depends upon whether Parliament has legislative competence under the 7th schedule read with Article 246. Under the 7th schedule, sports as a subject is not merely mentioned in the Union list, that is the list 1. Entry 33 of States list, that is list 2, deals with sports, entertainments and amusements. Prima facie, this suggests that regulation of sports falls within the legislative domain of state legislatures. However, constitutional interpretation does not end with literal reading. The doctrine of pith and substance must be applied. In Pith and Substance Doctrine, the National Sports Governance Act does not merely regulate sports as an activity. It regulates the governance of national level bodies representing India in international forums. This aspect connects to several Union list entries, which include: first is entry 10 and entry 14 of list 1, relate to foreign affairs and entering into treaties and agreements. National sports federations deal with international sporting bodies and represent India globally. Regulation ensuring compliance with international standards can fall within Parliament's power over foreign relations. Second, entry 97 of list 1, that is the residuary power, read with Article 248, grants Parliament authority over subjects not enumerated in state or concurrent lists. Since national level sports governance as a regulatory framework is not specifically enumerated, Parliament may rely on residuary powers. Third, if national sports federations are registered under central laws like the Societies Registration Act or Companies Act, Parliament can regulate their functioning through entries relating to incorporation and regulation of corporations, which are included under entry 43 and 44 of List 1. Further, Article 249 enables Parliament to legislate on state list subjects in national interest if the Rajya Sabha passes a resolution. If sports governance is treated as a matter of national importance, particularly in the context of international reputation and athlete welfare, such a route is constitutionally permissible. Judicial precedents emphasize cooperative federalism. Courts have held that where national interest, uniformity, and international obligations are involved, union intervention is justified. However, the Act must not encroach upon purely local sports administration or district level activities which remain within the state competence. Therefore, Parliament's legislative competence to regulate national sports federations can be constitutionally sustained if the Act is narrowly tailored to national international dimensions of sports governance. Overboard regulation of local sports bodies may invite challenge for violating the federal balance. In conclusion, while sports per se lies in the state list, governance of national sports federations, especially in relation to international representation, corporate regulation, and national standards of transparency, can fall within Parliament's legislative domain through Union list entries, residuary powers, and constitutional mechanisms. The key lies in respecting federal boundaries while ensuring accountability and national interest. Sports is mentioned in the state list under the 7th schedule, but national sports federations represent India at international levels. When Parliament enacts the National Sports Governance Act 2026 to regulate these bodies, a constitutional question arises. Can it legally do so? The answer depends on legislative competence under Articles 245 and 246. We must examine Union list entries like foreign affairs, residuary powers under Article 248, and the doctrine of pith and substance. The issue is not just about sports, it is about federal balance, national interest, and constitutional interpretation.